Good afternoon. My name is Miriam Harmatz. I'm the Advocacy Director of Florida Health Justice Project. Thank you so much for joining this webinar on protecting long-term care residents' rights in Florida. We're going to start the presentation in a couple of minutes. Next slide. As summarized in the program's description, the training objectives are to provide some practical tools for representing long-term care residents facing a variety of issues, including how to defend against an involuntary discharge, how to respond to a termination or reduction in needed therapy, how to draft or revoke a durable power of attorney, and what some of the legal options are that are related to assisted living facility discharges. Also, please note the link at the bottom of the slide to the website's page on the webinar. That has your CLE information, along with all of the speaker bios, and a huge thanks to all the speakers who are here today, as well as material. An extensive library of materials are there, and an evaluation form. We're also going to be posting a recording of the webinar and questions and answers that we may not have time to today. Slide 3. So as you can see, the agenda is packed, and we're going to save Q&A until the end. Please send your questions through the Q&A function on your webinar screen. And now I want to introduce Terry Cantrell, who will briefly describe the Long-Term Care Advocacy Project, which is a joint effort between the Department of Elder Affairs, Legal Services Developer, the Long-Term Care Ombudsman Program, and Florida's Legal Services Programs. And just note that the materials include a memo from the department announcing the program's launch and purpose. Terry. Hello, Terry. How are you? Terry, are you able to do your introduction piece? If not, we can move on to the agenda, and we'll go right to, and hopefully you can join in a little bit and we can hear more about the project and the Ombudsman program. I'm sure there will be some questions in the Q&A. Next slide.
Miriam,
there you are. Yes.
Terry Cantrell, she's attempting to talk, but we can't hear her.
Well, let's work. We have a little tech team. We'll work on that. But Terry, can you check your audio, perhaps? Or let's save some time for the end of the program, because this is an important project, and we want to make sure we have time for Terry to introduce herself to everybody.
Can you hear me now?
Yes.
You can hear me?
Yes.
Guys, I gotta be honest with you, technology makes me sweat.
Hello, Terry. So please tell us about the project.
So we have partnered with you all. Miriam described it perfectly, because as you guys know, the Ombudsman program is the first line of defense for seniors. We're in nursing homes, assisted living communities, and through our advocacy efforts, we really see firsthand how much our vulnerable seniors need us. To that end, we partnered with Miriam and the Florida Advocacy Project and forming this group so that we could do a better job to address certain things that we're seeing as systemic issues, if you will, discharge and transfers being one of them. So it's a project that we're super proud to support and to sponsor, and I can't thank you all enough for joining. And I'm so sorry, I just had this audio issue. But I want to kick it off to Toby to get us started. And again, thank you all for joining.
Thank you, Terry. I'm Toby Edelman. I'm a senior policy attorney with the Washington, D.C. office of the Center for Medicare Advocacy. Next slide, please. One of the most common problems we hear about in nursing homes is that the facility tells a resident, you've reached the maximum of therapy, or you've plateaued, or you're not progressing. What do these statements actually mean? Do they mean the person must leave the facility? What if the person has applied for Medicaid? What if the resident is already receiving Medicaid? What should the resident do? Next slide, please. Although most residents are eligible for both Medicare and Medicaid, they're called dually eligible, residents usually get therapy only when Medicare is paying. When residents are dually eligible for both programs, Medicare pays first. Medicaid is always the last payer. So this session is about Medicare only. In our experience, residents are often entitled to more therapy and more coverage by Medicare than they are getting. We're trying to correct that problem. Next slide, please. Therapy often stops too soon. Sometimes it's the facility that says the resident isn't eligible for more Medicare. Sometimes it's the Medicare Advantage plan. The so-called lack of progress or lack of improvement is not a valid reason to stop therapy. The settlement approved by the court in the nationwide class action Jimmo v. Sebelius that the Center for Medicare Advocacy did with Vermont Legal Aid, the settlement confirmed that Medicare covers therapy if therapy is necessary to maintain the resident's current condition or to prevent or slow the resident's decline or deterioration. The settlement applies to traditional Medicare and to Medicare Advantage. And because this is a nationwide class action, it applies to everyone in every state. The Jimmo settlement actually also covers home health services and outpatient therapy as well. What we often see in these cases is that the facility claims the resident is not progressing, but what the person really needs is more time to progress. By using Jimmo to get therapy to continue, the resident can get additional therapy services. Sometimes the resident ultimately actually improves. Next slide, please. 3 points are key. First, maintenance therapy services provided or supervised by a professional therapist are covered. These could be physical therapy, occupational therapy, or speech-language pathology. Second, residents can appeal if the skilled nursing facility or the Medicare Advantage plan says that therapy services will not continue. And we encourage people to appeal. Third, even if the resident loses the appeal, that doesn't mean the resident must leave the facility. Whether Medicare will pay for a resident's stay is one issue, but whether the resident needs to leave the facility is another entirely separate issue. Next slide, please. If a facility wants to discharge a resident for any reason, it must give the resident a written notice, and the resident has the right to request a hearing. These notice and discharge rights are required by the federal nursing home reform law, which Congress enacted in 1987, and they are totally separate and distinct from appeals about Medicare coverage. In addition, a new regulation from 2016 says that the facility cannot discharge the resident if the resident has applied for Medicaid and the Medicaid application is pending. That is not a non-payment situation, which is one of the permissible reasons for involuntary discharge. Next slide, please. The first level of appeal rights is different for traditional Medicare and Medicare Advantage. After these initial appeals, all residents get the same type of appeals. Next slide, please. The traditional Medicare program has 2 types of appeal, expedited and standard, and they serve different purposes. Next slide, please. I want to spend some time on what people are most likely to get, which is the expedited appeal. The notice is called the Notice of Medicare Non-Coverage, NOMNOC. The purpose of this notice is to help keep the services in place. This is important because Medicare will pay for a stay in a skilled nursing facility only if the beneficiary actually received the services that Medicare covers. If the resident is not getting therapy 5 days a week, or is not getting skilled nursing care 7 days a week, or a total of 7 days of skilled nursing and therapy, the three different ways to qualify for Medicare coverage, then Medicare won't pay for the stay. It doesn't matter that the facility should have provided therapy and wrongfully stopped it. Medicare just will not pay. Since many people are unable to pay out of pocket the $500 or $600 a day or more that facilities charge, the expedited appeals process was intended to try to keep the services in place without interruption and without requiring a resident to pay out of pocket while appealing. Unfortunately, the expedited appeal process doesn't work very well in practice. Many facilities don't comply with the extensive notice and information requirements. Families may not even know the basis for the denial of coverage. The process often feels to families and to us like a rubber stamp. In addition, even when people win an expedited appeal, the facility or Medicare Advantage plan may give the resident a new Medicare termination notice days later, and this happens frequently. So a success on appeal can be quite short-lived. Next slide, please. We tell people not to give up at the first level of appeal. A resident who loses the expedited appeal still has many options. She can continue appealing and should. And if the person remains in the facility and continues to get the services, she can get and submit a demand bill, which I'll discuss in a moment. But there are also other things to do. The resident can request coverage of therapy under Medicare Part B, same standard for GMO. So the maintenance is approved for Part B Medicare. If the resident gets therapy 5 days a week under Part B, this can later be converted to a Part A coverage for the stay. And finally, if the resident appears to have declined in the absence of therapy, she can request a reassessment by the therapy staff. If the facility agrees the resident has declined and now needs therapy again, and if there hasn't been more than a 30-day gap, she can resume her Medicare benefit period where she left off. So, for example, if the resident had 30 days of covered care and 10 days of non-coverage, then Medicare resumes, she would be in day 31 of her benefit of her covered care. So she would be in day 31. This is not our favorite option, of course, because Medicare does not require people to decline in order to get care covered, but it sometimes works to get therapy started up again for people, and that's important. Next slide, please. Just do one thing if I could for a moment with my computer too. These computers have their own minds. The second type of appeal is the standard appeal. The facility must give the resident the Skilled Nursing Facility Advanced Beneficiary Notice, SNF-ABN, and this form gets the request for coverage to the Medicare program. Residents are entitled to receive both the notices for both the expedited process and the demand bill process, but often they just get the expedited notice. It's important to get the SNF-ABN because administrative law judges considering an appeal from an expedited notice are actually just considering whether the resident was entitled to Medicare coverage, not whether the facility actually provided the level of care that Medicare pays for. It's a very, very confusing situation for all involved, including the judges who all do it in different ways. But the key point is get the SNF-ABN. Next slide, please. Medicare Advantage plans also allow the resident to appeal. Plan participants may request what is called an organization determination for coverage, both in advance and after services have been provided. So these are similar to the expedited and appeals in traditional Medicare. Medicare Advantage plans have their own forms and they may allow oral appeals. Depends upon the plan. Next slide, please. There are many levels of appeal which we can supply in supplementary materials, but in the experience of attorneys and advocates at the Center for Medicare Advocacy, people have the best chance of winning at the administrative law judge level. At that point, they get to tell their story about what happened and what the resident needed and received at the facility. Next slide, please. it is never too soon to start collecting evidence. All of this information might persuade the skilled nursing facility to continue providing care, and if not, it's useful for appeal. An important tool is the JIMO webpage that the court ordered CMS to develop. The webpage begins with what is called, quote, important message about the JIMO settlement, quote. This important message describes the maintenance standard of care for the setting, for all of the care settings, and then says, quote, the JIMO settlement agreement may reflect a change in practice for those providers, adjudicators, and contractors who may have erroneously believed that the Medicare program covers nursing and therapy services under these benefits only when a beneficiary is expected to improve, close quote. That's a clear statement that Medicare covers more than improvement. The JIMO webpage also includes chapters of Medicare Benefit Policy Manual, which were revised to clearly describe the maintenance standard of care. Chapter 8 is the skilled nursing facility chapter, and the revisions are all in red italics, which is a very visual image of the changes that JIMO made to the manuals. We encourage people to show facilities the CMS JIMO webpage, the manual, and the frequently asked questions, which can all be helpful in explaining what maintenance coverage is. We also tell people to get the medical records from the facility to review to see if the resident is getting care from a professional nurse and therapist. Most important is physician support. We have a template in the materials. Physicians often think if they order skilled care, they're done. But what we actually want and need is a detailed statement from the physician about what the resident actually needs specifically and why the resident is a good candidate for therapy. Families can also prepare their own declarations describing their relative's experience in the facility or earlier with therapy, and also about their observations in the facility when therapy was provided and how it helped their family member. Statements from therapists may also be helpful. Appeals before administrative law judges are informal, and residents and their advocates should bring whatever evidence they can develop. Next slide, please. The key points are that Medicare pays for maintenance care as well as improvement. Residents should do their best to get daily skilled nursing and therapy services and get the SNF BN and have the facility submit it. And finally, residents have the best chance of winning if they get to the administrative law judge. So keep appealing, don't give up. This is a quick summary of admittedly a very, very confusing issue, confusing to advocates who've done this for years and to the judges and certainly to families. But if anyone is interested in hearing more, I am presenting a session on JIMO and nursing home appeals on October 31st at the annual conference of the National Consumer Voice for Quality Long-Term Care in Baltimore. Consumer Voice will live stream all of the conference sessions and then we'll post all of them for 60 days after the conference ends. To get more information about Consumer Voice, go to their website, theconsumervoice.org, and you need the at the beginning, theconsumervoice.org. Thank you so much for a chance to talk about this important issue. And now I'm going to turn this over to Maria.
Good afternoon. My name is Maria Caruba Fuentes. I'm a staff attorney at Bay Area Legal Services, and I am a participant on this grant. My presentation today is going to be about addressing the unmet civil legal needs of a long-term care resident, roadmap of a success story. Next slide. My hope is that participants will take away from this presentation the fact that long-term care residents often have civil legal needs that are not related to their stay in the facility. I'm going to talk about Miss B, who was my client, and a success story as well as a cautionary tale. I'm going to talk about self-directed decision-making and tools we can provide to long-term care residents to assist trusted helpers. I'm also going to talk about what happens when there is an abuse of authority and a breach of trust, and the steps we can take to control the damage. Next slide. Miss B was my client, and she applied for services while she was a resident of a nursing home. She had been living independently in her home that she owned and unfortunately suffered a fall and serious traumatic injury requiring a hospital stay, multiple surgeries, and ultimately a stay in a nursing home for rehabilitation. At the time that Ms. B had her accident in the home, her son came from Georgia and moved into her home, and he came to the nursing home and he was helping her with acclimating to living in a nursing home. He was visiting her. He was bringing her drinks. He brought her a refrigerator. He was paying her cell phone, and he was managing her home and her vehicle and all of the things that she left behind in the community when she went into the facility. At some point, Ms. B's son approached her about signing legal documents, giving him authority to act on her behalf, specifically a durable power of attorney, as well as some medical directives. And she signed them thinking that this would help to facilitate her stay in the nursing home, as well as her goal to ultimately get back home. Next slide. What we need to be mindful of, again, is that just because an individual goes into a nursing home or other congregate care setting, they may not have the option of forgetting what is going on outside of the home. They own a home, they have accounts, they have responsibilities, and those things need to be attended to even while they're in the facility. And it doesn't mean once a person goes into a nursing home or a congregate care setting that they're not allowed to make their own decisions. Unless they've been adjudicated incompetent, the individual retains that right to make their own decisions, and that includes locating individuals that they trust to help them with doing things outside of the facility. And what Ms. B made very clear to me is that not every person that goes into a nursing home is going to stay there forever. Next screen. So when someone finds themselves in a long-term care setting, they do come to rely on individuals outside of the facility to help them address those needs. And an effective tool that can be used is a durable power of attorney. Ms. B did have a durable power of attorney, but unfortunately, as time went on, as she was in the nursing home, she came to realize that her son was no longer advocating on her behalf. And she unfortunately came to find out not only was he not advocating for her, he was also standing in the way of her ability to get home. So at her request, we did draft the documents required to revoke a durable power of attorney. We served them on the agent, so he was aware, as well as any others we thought that might have been aware of the existence of the power of attorney, just to let them know that this individual no longer had the ability to make decisions on behalf of Ms. B. After the agent was removed, because Ms. B did not have another trusted helper, I advocated on her behalf. I arranged a meeting with the nursing administrator at the facility, and we got Ms. B back on track to receiving physical and occupational therapies, which were crucial for her to be able to go home. When I first met Ms. B, she was not physically capable of living on her own, even if she were to receive home and community-based care. And I advised her that she would need to build up her strength and be able to do a few things on her own before she could go back. And Ms. B was bound and determined that that was what she was going to accomplish. Additionally, as part of her self-directed decision-making, at some point in her stay, Ms. B decided that she was no longer going to take the half cup full of medications that she was administered daily. She only took the 3 medicines that she identified by shape and color that she had been taking prior to her admission for the conditions that she came into the facility prior to her hospitalization. In addition to the physical and occupational therapy and ceasing to take those other medications, which we speculate were likely psychotropic drugs that are often administered to long-term care facility patients to keep them sedated and calm and to make them easy patients. So once we revoked the durable power of attorney and Ms. B was on her way to physical and occupational strengths, we did apply for home and community-based services, and she was able to go back home. But when she got home, her son was still living in the home with another unwanted occupant, so we needed to take steps to remove them from the home. So I gave notice to both occupants saying that their tenancy had come to an end and that they had to be out by a date certain, or if not, I would file an eviction action. Fortunately, they left without incident, and then she stayed in the home, and I'm happy to report that Ms. B is at home, living independently with home and community-based services, in addition to some home-delivered meals and some other assistance to keep her independent. Now back to the issue of the durable power of attorney. I've attached here a link to Florida Statutes Chapter 709, which deals with powers of attorney and similar instruments. Due to the time constraints of my presentation, I'm only going to go over those things relating to powers of attorney. Next slide. What is a power of attorney? Well, it's a legal document that an individual signs granting authority to an agent to act in the place of the principal. What is a durable power of attorney? And what would not qualify as a durable power of attorney? In order for the document to be considered durable, Florida statute requires specific language to be in the document that says that this document will survive the incapacity of the principal. Incapacity means the inability of an individual to handle legal affairs on their own. And it doesn't require necessarily a legal adjudication by a court. It just means that all outward signs point to the fact that the individual can no longer make decisions on their own. So that's why having that durable language in the power of attorney is crucial. If not, if the principal becomes incapacitated, then the document is no longer valid. So we have the principal who grants the authority, and then we have the person who's given the authority to act on the principal's behalf, and that individual is known as an agent. And the principal can appoint an agent as well as a co-agent to act on their behalf. If co-agents are named, they can act independently unless the principal requires that they have to act jointly. But Florida statute says if that language is not contained within there, the agents may act independently. A principal can also name a successor agent, who is someone that would stand in should the agent or co-agents resign or die or no longer desire to work, or they're removed. Additionally, what we need to remember is that an agent needs to be a natural person who's over the age of 18 and who also has mental capacity. There are other fiduciary relationships with banking institutions, but that's beyond the scope of my presentation today. But again, I direct you to the statute where it talks in more depth about those things. What makes a valid durable power of attorney? In order to be valid, the document has to be signed by the principal in the presence of two witnesses. And again, the principal must have legal capacity, and the document has to be notarized. Additionally, the document cannot contain a statement that says the document becomes effective at a future time. Florida does not recognize what are known as springing powers. The power becomes effective upon signing, and it remains in effect until the durable power of attorney is revoked or terminated as detailed in the document itself. Next slide, please. Florida statutes also defines the duties of an agent. And initially, what we need to understand is that an agent is a fiduciary. And what that means is that this individual has the duty created by their undertaking to act for the benefit of another person, and that they understand that this is a position of trust. Florida statute spells out the other duties that are required of an agent. They must act within the scope of the authority granted by the principal. They must act in good faith and meet the expectations of the principal, know and preserve the assets of the principal, and to the best of their abilities, they need to preserve those assets. Additionally, Florida spells out other duties that agents can be charged with, but those duties require special acknowledgement within the document by the principal with initials next to those superpowers, for lack of a better term, stating in fact that the principal is giving that authority to the agent. And these duties can include creating trusts, disclaiming inherited property, making gifts to other individuals, changing beneficiary designations and insurance policies, and other significantly important legal decisions. And that's the reason why that additional acknowledgement is put in there, so that the principal is affirmatively stating that they are giving those additional powers to the agent. What are the authorities entrusted to an agent under a durable power of attorney? Well, those must be detailed in the document and can include authority to mortgage and sell property, manage investments, handle banking situations, and things of that nature. It can also be limited. It can be for a specific reason. My agent is authorized to handle a real estate closing. And then once the real estate closing is done, that durable power ceases to have effect. But typically people do broad grants of powers under durable powers of attorney. There is no formal requirement that the agent accept the responsibilities of being an agent, but the principal must communicate to the agent that they are entrusting them with these responsibilities. There is a form that's called an acknowledgement by an agent, which can be signed and made part of a durable power of attorney, but it's not required and it doesn't void the validity of the durable power of attorney if the agent doesn't in fact sign it. And in no circumstances can an agent ever perform duties of the principal required under a personal services contract. They cannot make an affidavit as to the personal knowledge of the principal. They cannot execute or revoke a will, nor can they vote in an election. Next slide, please. So as we learned in Ms. B's case, there's often times where we need to terminate the powers that were granted in a durable power of attorney. And there are several ways that this can happen. The agent can resign or die, so no longer can act, of course. If the principal dies, the durable power terminates. It does not survive death. Or if the principal has become adjudicated by a court as someone whose rights have been terminated under a guardianship, oftentimes the language in the order will state that any powers that have been granted are no longer valid as a result of the guardianship being put into place. Additionally, if the agent named is the spouse of the principal and those parties ultimately divorce, Florida statute provides that the agent no longer has that role of an agent if there was a divorce, but the principal can override that with language saying that in spite of a divorce, I still want my former spouse to act in that capacity. Additionally, as I said, the document can have a time limit. It can be for a specific purpose. It can have a date range from October 1 to December 31st. I want a power of attorney because I'm going to be out of the country or some other circumstance. And then January 1, it ceases to have effect. So that would be by its own terms. Finally, a durable power of attorney can be revoked. And that's what happened in Ms. B's situation. It became necessary because the agent was no longer acting in Ms. B's best interest that we had to remove the power from the agent. And the way that a principal would do that would be either to draft a new durable power of attorney that specifically says that they are naming someone in place of the prior agent and that the document revokes the prior durable power of attorney, or as in the case of Ms. B, the requirement, she just did the revocation because she did not have a backup trusted helper to name as a alternate agent in her situation. So we just drafted a revocation document stating that it was no longer in effect and people were not to give validity to the document. So once you do a revocation or a termination for some other reason, you have to put people on notice. The statute does not require any formal notice, but says that the principal may give notice of the revocation to the agent who has accepted the authority with the acknowledgement form that I discussed earlier. But for all practical purposes, it really makes good sense to notify and make aware anyone who you think might know about the existence of the power, because Florida statutes protects anyone who legitimately and in good faith accepts a durable power of attorney that they have no reason to know is either invalid or has been revoked. So if they don't have notice and they take action, they're not going to be liable for what they've done. So providing notice is extremely important. That's the end of my presentation, and we'll accept questions later on. Next slide shows my contact information. If you have any additional questions, I'd be happy to answer them, and I'll be available to answer questions during the presentation, the portion for question and answers. And now I'm going to turn it over to my colleague, Ellen Cheek, who's going to do the next session.
Good afternoon. I'm Ellen Cheek, and as Maria said, I am at Bay Area Legal Services as a senior staff attorney on the Senior Legal Helpline. And I am here today with Ombudsman Joanne Keeles, and we are here to discuss involuntary discharges from an assisted living facility, to explain why it's an issue elder advocates should be aware of, and to advocate for stronger statutory protections for ALF residents facing discharge. Next slide, please. Chapter 429 Florida statutes defines an ALF as any setting which provides housing, meals, and at least one personal service over a period of more than 24 hours to one or more individuals who are unrelated to the owner or the administrator. Pretty broad definition, and many facilities qualify. Assisted living facilities, or ALFs as we'll call them today for brevity, are licensed and regulated by AHCA, the Agency for Healthcare Administration. But they are not healthcare facilities. In fact, the Florida legislature was very explicit about that, and 429.01 provides, in support of the goal of aging in place, the legislature recognizes that ALFs should be operated and regulated as residential environments with supportive services and not as medical or nursing facilities. Next slide, please. So, assisted living facilities are residential facilities. As you can see, they certainly have features in common with both skilled nursing facilities on one end of the long-term care housing spectrum and with independent living arrangements on the other end of the continuum. But ALFs are unique residential environments with a statutory purpose to accommodate individuals so as to promote aging in place. What that means is, and what usually happens, is that an ALF is usually considered long-term care housing, and an ALF resident generally considers the assisted living facility home. Of course, things and people change. Medical conditions and finances are two big ones. And when an individual's medical condition or budget changes, residents often decide to move. But what happens when the facility decides a resident must move? Well, that's called an involuntary discharge or facility-initiated discharge, and that is our topic for today. Why is it important? Florida currently has more than 3,000 licensed assisted living facilities with a capacity to accommodate more than 106,000 individuals. Currently, tens of thousands of elderly and disabled Floridians call an ALF home. And because although ALFs share characteristics of both skilled nursing facilities and rented dwellings, ALF residents, many of whom are among Florida's most vulnerable citizens, have less protection than either a nursing home patient or a tenant in a rental when it comes to discharge. And finally, when a vulnerable adult is discharged from his or her ALF home, the landing is not always a safe one. Many discharged elders end up in emergency rooms, shelters, or back in a home which couldn't accommodate their needs to begin with. Next slide, please. So let's talk about what's involved with an involuntary discharge from a Florida assisted living facility. This could be quick. There's not much, and that's part of the problem. All that is required is a written notice giving a resident 45 days for termination or relocation with the reason for the relocation and the information that the resident may contact the long-term care ombudsman for assistance with relocation. No notice at all is required for a medical emergency, or, and I'm going to quote, when a resident engages in a pattern of conduct that is harmful or offensive to other residents. Well, there certainly can be situations where an emergency discharge might be justifiable, but that the latter standard in particular is so broad as to include a very significant range of behavior, and that can be a problem. Next slide, please. What's not included in the Florida statute? Any right to a hearing or an administrative appeal or an opportunity to cure. And by opportunity to cure, I mean an opportunity to meet with the facility, for example, to address the situation that triggered the involuntary discharge and see whether any accommodations are possible. Things like changes in medication or changes in schedule, or possibly even elopement prevention measures rather than a discharge. Well, because there is no clear way under current law to challenge a 45-day notice, most people, including residents, ombudsmen, and attorneys, not to mention the facility administrators themselves, assume that once a 45-day notice issues, the resident has no choice but to vacate as soon as possible. Next slide, please. And although Chapter 429, as currently written, gives advocates very little to work with, there are options. Our advice: do not assume there's nothing to be done. Do not leave immediately. Do call the long-term care ombudsman, which is what I'm going to do. Joanne Keelys is a deputy long-term care ombudsman with more than 14 years experience with the Florida Long-Term Care Ombudsman Program of the Florida Department of Elder Affairs, and she will share some of her advocacy tips with you when she meets with a resident faced with a notice of involuntary discharge. Joanne?
Thank you, Ellen. Hi, next slide, please. Okay, so some of the advocacy strategies that I use, number one, obviously, is not to assume there isn't anything that I can do just because the ALF resident does not have the same protections. I like to gather as much information that I can as to why the facility is discharging the resident. I have to see if this is a memory care facility and the resident, this facility advertises that they specialize in memory care. And the reasons they are discharging the resident, for example, is because they're exhibiting behaviors. There's a valid conversation and an argument to be made on behalf of that resident. Also, if the resident is on Medicaid, with their consent, I can contact their case manager with the Medicaid provider. And oftentimes I find they are a good resource, and they do assist sometimes with relocation, as well as trying to see if there's anything they can do to assist the resident to stay in the facility. But above all, I mean, sometimes you come across a discharge and the resident really doesn't want to stay. And so in that case, we would assist them by providing a list of facilities that are in their area and that could accommodate this particular resident. But there's always something that can be done to advocate for the resident. So oftentimes there's underlying reasons for the discharge, and just an ombudsman speaking on behalf of the resident and meeting with the facility and the resident at the same time can facilitate rescinding of the discharge letter. Next slide.
Thank you, Joanne.
Thank you.
Advocates, whether you are the ombudsman and now or the attorney, be realistic with the resident. Under Chapter 429 as currently written, the resident's right to stay in the facility is not guaranteed. But with their permission, initiate a meeting to determine whether there's an opportunity to cure, as Joanne said. If this hasn't already been a step that hasn't already been taken by the ombudsman, see whether there isn't some remediation possible or some other approaches which will allow the person to stay in the facility to be comfortable with that situation. As an advocate, you can point out how the facility's action may violate other relevant laws like state and federal fair housing acts, or form the basis for an ACA complaint. And you can point out that those are steps that might be appropriate in this case if because of the facts as you see them, and explain that position to the administration. If the resident can stay in touch with the long-term care ombudsman to monitor so that the resident's care and treatment during the continued residence can be monitored. Retaliation is prohibited under Chapter 429, but unfortunately, it is not uncommon. And the long-term care ombudsman can be the eyes and ears and just monitor the situation to the resident's advantage. But like Joanne says, sometimes there are times when the resident either doesn't want to stay or an accommodation cannot be reached with the facility, and the resident has to move. You can negotiate for more time for relocation. You can also seek the services of a private third party known as a senior placement advisor. I've just learned about these people recently, and an involuntary discharge from an assisted living case that I was involved in. These, as I say, are private third-party providers who are usually extremely familiar with the resources in the community and often have relationships with other administrators. And they can really help, especially a vulnerable or unsupported person, find a new facility, a good, safe place within that very short time period that Florida statute allows. My understanding is that there is no charge to a resident for this service, but that I believe that the senior placement advisor is paid by the receiving or the new facility. Next slide, please. By this time, you're thinking, surely there's something else we can do. Well, from the point of view of the individual resident, there are steps that can be taken by an advocate. It may not very likely will not keep them in the facility, but there are steps that can be taken. Those with Medicaid managed care might have more leverage and as Joanne said, contact with their Medicaid managed care caseworker can help with that. And an ACA complaint, a complaint to the Agency for Healthcare Administration, the licensing and regulating agency for an assisted living facility, is appropriate if you believe the residents' rights were violated. A fair housing complaint under either state or federal law may be appropriate to the extent you believe the facility will not accommodate a resident's disability and things like accommodations like elopement prevention for a patient suffering from dementia is one example. And I would urge advocates to consult the excellent resource in Florida called Disability Rights Florida. Advocates who are have tremendous expertise in fair housing and who are very generous with their time to consult with other advocates. And finally, I would like to quickly mention something called the HCBS settings rule. So historically, federal regulations have not impacted assisted living facilities because, as we've noted, they are not healthcare facilities. But since assisted living facilities were authorized as a setting for a resident to receive home and community-based services funded by Medicaid, some federal Medicaid regulations do apply. And the HCBS settings rule refers to a federal regulation that says a facility that is authorized to accept Medicaid for a resident receiving HCBS services, that the state must provide that residents in that facility receive at least as robust protection as a tenant would receive under that state's landlord-tenant law, in our case, Chapter 83, Part 2. Florida, despite the fact the deadline for compliance, state compliance with that federal regulation has passed, many of us believe that Florida is nowhere near compliant. And although ACA, Agency for Healthcare Administration, is still working on a rule to bring Florida into compliance. So at the very least, advocates should watch for any rule ACA does promulgate. And again, that would be to give Florida ALF residents at least as much protection as a tenant in a landlord-tenant context in Florida. Next slide, please. But the real hope, I think, and the really important mission I think we must embark upon are ideas for statutory change. Florida's the Assisted Living Facilities Act, Chapter 429, is simply does not afford this vulnerable population the protections that I think they need, and especially when it comes to involuntary discharge. We can glean several good ideas for legislative change from certain other jurisdictions' efforts. One such is Minnesota. It appears that Minnesota's ALF statute underwent a pretty significant overhaul a couple of years ago. And some of the measures they've adopted are really provide food for thought. One is a required pre-termination meeting as a prerequisite to issuing a notice of involuntary discharge. That would be an opportunity for cure. It could involve the resident. And if everybody can get around that table and talk, it may well promote Florida's goal of providing an opportunity to age in place. A provision for an administrative appeal. Due process requires nothing less. And finally, relocation coordination. Not just a suggestion, but a requirement that the facility that seeks to discharge the resident participate in meaningful relocation coordination to assure that that discharged resident lands safely in an appropriate setting in the community. So that concludes my remarks. I would like to say that a legislative effort takes all kinds of collaborations, and your stories are critically important to explaining to legislators how what's going on in the community, what's going on with assisted living facility residents. Please be in touch with your questions, with your input, and with your case stories. Our contact information is on the next slide. Thank you very much. And now I will introduce our colleagues on the grant, Jim Kowalski and Katie DeBreer.
Good morning, everyone. Thank you for joining us today. I'm going to try to move through these slides within the next 20 minutes so that we have plenty of room for questions. I see in the Q&A that lots of good questions are coming in. So I'm Katie DeBreer. I'm the legal director for the Florida Health Justice Project. And with me today, I'm grateful, is Jim Kowalski, executive director, president and CEO of Jacksonville Area Legal Aid. And we're here today to talk about the anatomy of a successful nursing home discharge case. So what do you do when you get a referral for a client who is being actively discharged from their nursing home? Next slide, please. So what we'll go over today in our lovely Halloween themed PowerPoint is as follows. Starting off with the ombudsman referral. So Jacksonville Area Legal Aid partners with the Florida Long-Term Care Ombudsman, who actively send referrals to JALA for assistance with individuals who have been referred to the ombudsman for discharge, to defend against a discharge. We're then going to talk about the intake and case review process. So getting the initial information and deciding whether or not it's a case that should be accepted for defense. Filing a hearing request with the Department of Children and Families Office of Appeal Hearings, as it's an administrative level appeal. Discovery and motion practice once the appeal is filed. The hearing, and then any post-hearing issues. Next slide, please.
Katie, I think this one's mine. So let's start with inviting some of our special guests on. I think we've got Tracy from our local ombudsman office, and we also have Joanne, who I think you heard from a little bit in the last section. So Tracy, let's start with you. You're our local ombudsman. You run a department of primarily volunteers, but if you could, please, let's talk a little bit about what you see as the ombudsman's role in referring cases. How do you look at this enormous volume of discharge notices you get? I think we've heard from some sources that there's roughly 35,000 of these notices that get to the ombudsman each year in Florida. How do you look through those, sift through those, and decide what you then refer on to civil legal aid?
Oh, Tracy, I believe you're on mute.
Okay, we do get a lot of transfer and discharge notices. When we do receive them, we normally receive phone calls either from the residents or the families in regards to the transfer and discharge notice that they received. Once I receive that phone call, then I have a checklist that I go through before I think about referring them over to JALA. I want to make sure that all of the paperwork is filled out properly. The resident has received a copy of it, which sometimes that does not happen. Once we have received consent from the resident and or family, then we can open up a case, which allows us to look a little bit deeper into that. So we'll go through and make sure that the effective dates are on there, that there is a proper transfer location, and it's a safe discharge, trying to look at the reasons for the discharge. And then we can kind of determine whether or not this is something that getting JALA involved would be beneficial for the resident. So far, I think it has worked out wonderfully. It has been a very beneficial tool to be able to work with you guys. And we've had very successful transfer and discharges where the resident originally did not think that they were going to win, and we ended up winning quite a few hearings. So there are some steps that we do go through for sure. Even once it is transferred over to and JALA has accepted the case, we still keep in contact with the resident and the families just to see how things are going. And we get multiple, I'll have some conversations with them and find out some information that maybe the attorneys are not aware of. So we share that information so everybody has the same information. So I think the lines of communication, keeping those open, working with Jim's office specifically, we've been really good with keeping those lines open. And one of the cases that we worked on, Jim and I, on separate occasions, were out at a facility or out at a hospital, actually looking for a resident's car. So, we're able to keep those lines of communication open and everybody's on the same page.
I just want everybody to know that I'm the one who found the car, just so that
yes, you did. Yes, you did.
Sorry.
No, you're good. You're good. But yeah, it's been very beneficial. So then once I think it's going to be something that would be a solid case, I'll go ahead and refer it over to you. We may or may not have a conversation about what our thoughts are as far as why. Most times we do. And then you guys have taken over getting the hearing set and have been wonderful inviting us in for depositions and just kind of keeping us up to date with what's going on. And then obviously letting us know what the conclusion of the case was.
And Joanne, if you could unmute yourself as well. I think you were just on this last session. I know you've also developed a checklist for what you look at. Again, the volume that the ombudsman offices get from the volume of notices that you get are just overwhelming. If you could speak about your checklist and how you go through and triage initially to determine what gets referred over to your local legal aid. And then also, if you could speak a little bit about some of the stuff Tracy talked about in terms of that post-referral investigative work, not always driving around a hospital trying to find a Kia, but whatever is involved in your cases.
Right, right. Yeah, I created the discharge checklist just off of things that I normally look for on a discharge notice. I make sure that everything that is required is on that discharge notice. That there's a safe location where the resident is being discharged to. A lot of times we'll receive a discharge notice and there is no location indicated on the discharge form. So yeah, I have shared the discharge checklist with everyone in the program, and I believe everyone is now using it. But it's important to note that, you know, depending on the reason, and actually regardless of the reason for the discharge, once we become involved, it's important to stay in communication with the resident. Also, if we're referring it, obviously with the legal system, just to be sure that their care is not, you know, not being affected, the quality of their care. But that's what I have.
And as Katie just noted, the checklist is in the materials. We'll be referring to a number of documents throughout this presentation, all of which are in your materials, either as templates or examples drawn from actual cases. So thank you to our two guest stars for jumping in at this early stage on how the case actually gets to the civil legal aid from this volume of referrals that our ombudsman offices get across the state.
Thank you.
Thank you.
Next slide, please, Katie.
Yeah, so after the referral comes to civil legal aid, what happens next? An intake, right? So the client calls and you begin to collect the information needed to do an initial review of whether it's a case that should involve an attorney in representing the client in defense of the discharge. The first and foremost document that you need to make sure is being collected, if it exists, is the discharge notice. And I have a link here. Brian, can you click on discharge notice, which should upload the template from ACA that skilled nursing facilities is part of their licensing, and that's fine. Skilled nursing facilities as part of their licensing with the Agency for Healthcare Administration is required to use as the template for the discharge. So when your client provides you that discharge notice, it should be that form from ACA. That form, of course, is going to contain the reasons for the discharge, which will help you take, for example, Joanne's handy dandy checklist and be able to compare the two to see if there are any deficiencies in the discharge notice itself, as well as in the reasons for discharge. Additionally, we recommend collecting decision-making documents. So Maria just went through a wonderful presentation about how a durable power of attorney played into a client's case that she assisted with. Of course, you're dealing with clients a lot of times in skilled nursing facilities who may have issues, diminished capacity, or be incapacitated. So you want to make sure that you have the documents that give the permission to whoever is speaking on their behalf to retain you and speak with you. That, of course, can range from a variety of things, including your client's verbal permission, healthcare surrogate, durable power of attorney, etc. And then particularly if the discharge notice highlights reasons for discharge related to the medical condition of the skilled nursing facility resident, you want to start collecting medical records, any medical records that family members or the client might have, as well as ensuring that a proper HIPAA release is signed so that you can obtain any needed medical records from the skilled nursing facility itself. And then finally, one thing that I would recommend upon intake is getting either Medicaid notices or most ideally, the login information for an individual's access account with their permission, of course, so that you can review whether or not any pending Medicaid applications exist and where in the process they are. This, of course, is related to, as Toby mentioned earlier, reasons for discharge being non-payment related. If there is a pending Medicaid application or Medicaid eligibility is in place, then the nursing facility cannot discharge for non-payment. So that's the kind of information that you really need at hand to be able to adequately assess whether or not there are viable defenses to the skilled nursing facility discharge.
One quick point about this, one quick point about this slide is this concept of using the discharge notice and the decision-making documents to narrow your focus, right? What your goal is here at the intake stage, at having FHJP get involved with pulling other prior cases, is you're trying to have the nursing home's position understood by you and the resident, right? The nursing homes may take multiple positions in the discharge notice. It may be confusing where the resident is going to be sent. The resident, the place where the resident is going to be sent may not even be listed, I think, as Tracy just referenced. So the goal here as you go through this process is you're narrowing their focus and making sure you understand what their position is. And as we'll discuss a little bit later, all of this against the context of 43.15, because all of the documentation for any of the reasons that are listed in the discharge notice must be in the medical record. In fact, the provision says when the facility transfers or discharges a resident under any of the circumstances specified, the facility must ensure that the transfer or discharge is documented in the resident's medical record and appropriate information is communicated to the receiving healthcare institution or provider. So again, you're using the statutes, you're using the forms, you're using prior decisions, and you're narrowing your focus to where the nursing home wants to be in order to discharge this particular person.
And Jim, I'll just note too on the discharge notice, so we showed you the sample form that skilled nursing facilities are required to use. We also have a sample form in the documents of a completed discharge notice so that you can see what Jim is talking about, some of the reasons that nursing facilities put in to a discharge notice to explain why the discharge is occurring. Next slide, please. So case review. So you've collected your documents, you've done your initial intake and gotten the basic information. Now the question is this a case that an attorney should enter a notice of appearance and provide a defense to the skilled nursing facility resident? As a really basic first question, we found a few times in providing technical assistance under the DPOA grant that individuals who are contacting civil legal aid for assistance may not know whether the facility they're being discharged for is in fact a skilled nursing facility. So this I put as the primary first question that you should be asking yourself upon collecting all of the necessary information. If it's not a nursing facility, then the Nursing Home Reform Act and the definitive reasons why a nursing facility can discharge do not apply. So the Nursing Home Rights Act does not apply if it is not a licensed nursing facility under Chapter 400. Instead, we have had instances where individuals are being discharged from a hospital or a short-term rehab facility. Ellen just went over an incredible presentation about the difference between discharges from assisted living facilities versus nursing homes. So those settings that are not nursing facility settings, the Nursing Home Rights Act does not apply, and the discussion of the defenses available and this administrative appeal process would also not apply. How do you know it's a nursing facility? Well, we've hyperlinked here a link to the Agency for Healthcare Administration, where you can look up the name of the facility and determine what type of facility it's licensed as. It's also important, though, there are facilities that host both short-term rehab as well as nursing facility. So that's an instance where perhaps speaking with the ombudsman and really understanding where in the facility the resident resides so that you know whether or not the Nursing Home Rights Act applies. In terms of the defenses, reasons that a nursing facility can discharge, Florida Health Justice Project has put together a fact sheet that helps advocates sniff out whether or not the nursing facility discharge is a lawful one. And that is hyperlinked there as defending evictions from Florida nursing facilities. The governing law that's cited in that particular handout includes Florida Statute 400.0255, 42 CFR 483.15, which Jim Kowalski just referenced. Appendix PP to the CMS State Operations Manual. This is a very weedy manual, but if you're undertake this work, I strongly recommend digging in, because what it does is really fleshes out the federal regulations in terms of, practically speaking, what looks like a violation or not. And then another wonderful national organization, Justice and Aging, and in particular, the advocate Eric Carlson, has done a ton of work over the years on nursing facility discharges. And I strongly recommend going into their website and reviewing the materials that Eric has created. Then one final place, probably a little deeper into your case review, you've decided to accept the case, but you want a sense of particular arguments that you're going to make, is the DCF, the Department of Children and Families, publishes prior skilled nursing facility discharge decisions online. We have a link to those prior decisions there. It's not precedent, but I would say two things. Under Chapter 120, state agencies have to reach consistent opinions. So if you find a decision that you would like the hearing officer to follow, same legal arguments to be applied, then they cannot reach a contrary decision as it's a violation of Chapter 120. Similarly, just looking at the way that hearing officers implement particular aspects of the law is very helpful in deciding how to frame out your arguments and also your requests for discovery. Jim, anything on this?
I would point to that last issue. We've referenced this before, but the prior hearings are invaluable, especially to those of us who are new to this area of law. We haven't, my background is in state and federal court and appeals, and so I don't have a ton of experience in administrative hearings. So I know our office has leaned heavily on FHJP and the research that they've done, both in helping us structure the outset, the triaging of the case, and then using these prior appeal decisions to help decide which areas to focus on in the case that we're looking at the moment.
Next slide, please. So I'm just not going to, for the interest of time, I'm going to go really high level on the slide and say, in terms of your issue spotting, understanding the reasons why, the finite reasons why a facility can discharge and comparing it to the discharge notice, strongly recommend Joanne's checklist as well as the FHJP handout that was hyperlinked in the earlier slide. So for the remaining portion of this presentation, we're really going to talk just about the mechanical aspects of defending the hearing. Next slide. So filing a hearing request. This is what's going to initiate the appeals process with the Department of Children and Families Office of Appeal Hearings. Much like the discharge notice form, there's a form that ACA publishes that individuals can use, meant to be a pro se form that individuals can use to file with DCF Office of Appeal Hearings. We have the form hyperlinked here, and also in your materials, you have a sample form that Jim completed on behalf of a client. And you'll see there that some of the strategies Jim invokes in terms of requesting that initial hearing. If you request the hearing timely, and we can't ever say this enough, if you do it within 10 days from receiving the date of notice, then the individual cannot be discharged from the nursing facility until the end of the hearing. Jim and I discussed this when we were preparing for this presentation. While a notice of appearance shouldn't technically be required, we all know that in state and federal court, your notice of appearance is simply your signature block on the first pleading filed. We find that at the Office of Appeal Hearings, they really appreciate a notice of appearance being filed. And I think that's because throughout your time in the case, you're going to have to call the Office of Appeal Hearings. Why? Well, that's for this fourth bullet here, because there is no online docket. So you're really not going to be able to keep track of the court's decisions on things. You're going to have to call and check the status on, for example, a pending motion for continuance. So if the clerk, whoever answers the phone, can easily see that you've filed a notice of appearance and therefore have permission, have the authority to receive information about the case, that certainly makes their lives easier. To that end, in filing the request, what we always recommend doing, you can file the request via telephone, by calling the Office of Appeal Hearings. You can send it via mail, and there's actually on DCF's website, which is hyperlinked here, there's a function that allows you to submit it electronically through their website. However, we recommend emailing the Office of Appeal Hearings, because that, of course, keeps a record of filing the hearing request. And then in my personal practice, I tend to stack all of my other filings on top of that filing of the initial hearing request. In that way, since I don't have an online docket, there's kind of a makeshift online docket in my email system. And then the filing of the hearing request, what goes in the hearing request, et cetera, is controlled by Chapter 65-2, which controls all procedures for hearings at the Office of Appeal Hearings with DCF. And I would like, Jim, if you have anything to add, please do.
Now I think we're ready for the next slide.
So I'm going to leave much of this slide up to Jim. I will just note that discovery is governed by Florida Administrative Code Rule 65-2.057 subpart 6, which incorporates by reference the Florida Rules of Civil Procedure, so long as they don't sit in opposition to anything under Chapter 120. Conflict with anything in Chapter 120, I should say. And that's going to include requests for production, interrogatories, requests for omission, as well as depositions. And this is certainly Jim's area of expertise, so I'm going to turn it over to him.
So I think we've talked about this, Katie and I, in developing these cases. I know my most direct form of discovery is a corporate rep ducis tecum deposition. And what it does is it really combines two discovery tools, the deposition with the request for production of documents, into one mechanism. And it's difficult for an opposing party to object to a deposition generally, right? This is just a chat. I just want to talk to somebody about the position that you've taken in this nursing home discharge vis-a-vis the statute and the regs and the medical records that support, as required, this discharge. When you do a corporate rep deposition notice, you're not deposing an individual. You'll get an individual as the deponent, but what you're doing is you're telling a corporation or a business the areas, the topics that you want to talk about, and you are telling them what documents you want them to bring to the deposition. And then it's up to the business to designate one or more humans to speak for the business and bind the business or the corporation as to those areas of inquiry and those documents that you want to discuss. So you can have 4 topics of inquiry. We've contained or attached a proposed or a sample deposition ducis tecum notice in your materials. If you have 4 areas of inquiry, the business can produce 10 humans to talk about those 4 areas of inquiry. And then typically you'll have some give and take about who's going to cover paragraph 1, this sentence, paragraph 2, this part, and you'll have some discussion on that. But the goal is then that you have the corporation bringing the people who will talk about, in this case, the discharge notice, and most specifically under 4315, the documentation that has to be in the medical record to support this discharge. I've always preferred, in this setting, in banking settings, in my other work, I've always preferred to do the corporate rep deposition ducis tecum at the facility or at the bank or at the debt collector, whoever it is, because typically that's also where they're housing the records. Now, you will find some pushback on that. Most of the times lawyers will tell you, no, this deposition has to be at a court reporter's office. All that's really doing is slowing it down, because invariably the deponent, whether it's a bank or a debt collector or a facility, is not going to bring all of the documents that are responsive to your request. And typically the deponent will say that, oh, I have more records that I didn't bring. And so if you're at the facility, you can take the break. The deponent or somebody on staff can get you the rest of the records, and you can proceed accordingly. If you're taking it by Zoom or at a court reporter's office, you're going to have a 30-day delay. So as long as the facility is okay with endless delays because their deponents are never bringing the right documents, that's fine. The resident's going to stay there during that entire period. If you want to be a little more efficient, if you're representing a facility, let's have the deposition at the facility so you can move the case along. All we're trying to do is get to the facts and the documents in the medical record that by regulation must support the assertion in the discharge notice. So you'll go back and forth, you'll pick your topics, you'll pick your location, and you'll have your corporate rep depo. Next slide, please. So I asked, this is the only slide that I asked for specifically. And this is just because of how I think of depositions. I think of depositions in terms of cartoon thought bubbles. So when you're taking a deposition, you want to have a mindfulness of the purpose of a particular group of questions, right? If you're taking a deposition ducis tecum and the nursing home provides its administrator, one of the first questions you want concreted in is whether he or she agrees they're governed by 483.15. That Q&A, and we've included a deposition in a prior discharge case in your materials where this actually was a topic, that Q&A needs to end up being tight and confined because you're lifting that and you're moving it over to something else, whether it's a motion, whether it's cross-examination. If you have a unrestrained Q&A with a witness that goes on for several pages and covers multiple topics, you can't take that out and move it into a motion. And this is true for discovery in general. So depositions, just like your case approach, are narrowing. They're an exercise in narrowing. And while you get to the final point, you want to make sure that you're asking some conclusory questions, some summation questions, because again, you want to take that chunk and move it into something else, whether it's cross-examination, motion for summary judgment, or anything else. Katie, anything to add about my ghost with the cartoon dialogue bubble?
He looks surprised as he learned a new fact. That's good for his case.
All right.
Next slide, please. So I'm going to quickly run through this. We have tons of samples in the materials about common motions that we need to file, including a continuance, which is always, to the benefit of you and your client. It gives you the time to prepare for the hearing, and the client is not harmed during that time because they're staying at the facility. The one I really want to focus on here is to set hearings via Teams or at the facility. Since we're a statewide organization, we generally request to set via Teams, as opposed to when you get the initial acknowledgement of hearing requests from DCF, they're going to set it by phone. We never recommend having a hearing by phone. It's just too clunky and complicated and very difficult to get your points across. So alternatives would be Teams. DCF also is mandated to provide a hearing in person if you live regionally in the area of the client. And then I know Jim's been successful having hearing officers set hearings at facilities. So since he's been successful, it's something to keep in mind as you move forward in terms of moving for a particular location for a hearing.
I think it's just easier. I think it's easier for everybody. Frankly, I think it's easier for the facility to bring their staff. A lot of times the hearing is going to be in the cafeteria or conference room. And it's certainly easier for our clients, many of whom are disabled, mobility affected, and they're more comfortable as well.
Yeah, absolutely. Next slide, please. And then the hearing. Again, we just touched on the location and the variety of options. And the hearing really is a mini trial. So you need to set aside some pretty significant time to develop your order of proof, craft your directs and crosses, your opening. For closing, I tend to reserve in closing my closing and instead provide a proposed final order where I make all of my legal argument and set out the facts that were established during the hearing. This, in the instance of hearing officers who are grossly underpaid and grossly overworked, I think appreciate it when the lawyers clearly set out their legal argument in terms of the hearing officer thinking through what the final decision will be.
And reference to the evidence. In other words, your final order needs to reference to the evidence that was actually submitted by the parties or adduced at the hearing.
And to that end, we always recommend having a court reporter at the hearing, and then you can get a transcript of the hearing to include those sites with your final proposed order. But again, as Jim and I were preparing for the hearing, he did note to me, and Jim, you can jump in here, that the court reporter's record will not be the official record of the hearing, that DCF creates its own audio transcript. And of course, post-hearing, which is next slide. You will have the right to appeal any decision to the District Court of Appeal. And again, that official record is going to be the transcript that was created by DCF. That's an entirely different presentation that we will skip here. But some post-hearing issues, you've won the hearing. Next steps are perhaps the nursing facility and your client have an, irreconcilable differences type situation. Your client would like to move into a different setting. So we have some resources here that discuss, for example, the resident's rights to move into the long-term care waiver after 60 days of institutionalization in a skilled nursing facility. To that end, if you have clients who have spent 60 days or more in a nursing facility and are struggling to get enrolled in the long-term care waiver, that is certainly something that FHJP is available to offer technical assistance for. And with perhaps 2 minutes remaining for questions, that is the end of our presentation.
Thank you so much. We do have some great questions, but we're at 1:30. So what I'm going to do now is ask the presenters if they don't mind. I'm going to forward the questions to them, and we are going to get the Q&A posted on the webinar's website, which Nicole and Brian have shared, and it's on this last slide. And many thanks to everybody who participated in this webinar.